morning, everyone. Thank you for coming in the nice, beautiful 10 in the morning on a Tuesday. Let me introduce the panelists. Well, myself, I'm Financial Faiz. Maybe you have seen me here and there. But for today's first panelist is Encik Jawahar Ali, Amir Ali. He's the General Manager for Consumer and Investor Office with the Securities Commissions of Malaysia.
Yeah, thank you, everyone. Thank you for having me.
Thank you, Encik
Faiz.
Jawahar.
Yeah.
The second panelist today is Miss Winnie Chan. She is the Senior Case Manager for Dispute Resolution under the Securities Industry Dispute Resolution Center, SIDRAC.
Thank you, Jeff Faiz. Thank you, everyone. Good morning, everyone.
Thank you, Winnie. And last but not least, we have Puan Sahlawati Mustafa. She is the General Manager, Regulatory Services Division under the Federation of Investment Managers Malaysia.
Assalamualaikum. Good morning, everyone. Welcome to the webinar. Thank you for inviting me for this session.
Waalaikumsalam. Thank you, everyone, for being here today. So, Encik Jawahar, you're going to be my first panelist. May I ask you to introduce your organization and its role in the capital markets, as well as for individual investors and their role in the investing processes?
All right. Thank you, Faiz. The SC was established in March 1993 under the Securities Commission Act. We are 30 years old this year, and the SC, we report to the Ministry of Finance, and its accounts are tabled in the Parliament annually. We are self-funded statutory body, and we are entrusted with the responsibility to regulate and develop the Malaysian capital market. For those unit trust consultants, you may know where our building is. It's in Bukit Kiara. If you're a unit trust consultant, whatever, you need to come and sit for your exams. It is actually opposite the Pusat Sains Negara, and that's the only venue or only building office that we have. SC has got no branches, unlike Bank Negara or SSM. SC is the only one office which is in Bukit Kiara. Now, what is our role? We have a mission statement. The mission statement reads, the SC's missions are to promote and maintain fair, efficient, secure and transparent securities and derivatives market, and to promote the orderly development of an innovative and competitive capital market. Those are a lot of words. Now, what does this actually mean from the perspective of investor protection? So how do we do it is through rules and regulations. Example, we supervise the conduct of intermediaries. We carry out surveillance of the market, and in terms of scams and unlicensed activity, which is a nuisance right now, which is we're having a huge problem with that, as many of you would be aware. So we do various intervention efforts, intervention initiatives, such as we update our SC's investor alert list regularly. Now you may know that the investor alert list, it contains names of identified parties that have been found to be promoting scams or unlicensed activity. Concurrently, we also, with the assistance of the MCMC, we block websites, we block the social media accounts and whatnot. That would be our initiative with respect to curbing or combating scams and unlicensed activity. But of course, what is more important is to empower the Malaysian publics to arm themselves with the necessary knowledge, so that they would be a wiser, smart investor, and at the same time they can protect themselves against scams and unlicensed activity. Now, how do SC does that? We have our InvestSmart brand. This is our platform that we use to carry out all our investor education initiatives. Now, just to give a bit of a background of all the interventions that we have taken, with respect to scams and unlicensed activity, we have, in this year alone, we have commenced 7 enforcement actions, and we have included about 300, more than 300 names on our investor alert list, 304 to be specific. And also we have blocked about 185 websites, and with the assistance of Facebook, we've already blocked 38 Facebook pages. And of late, we realized that a lot of these scams and unlicensed activity has been carried out through Telegram. So we have blocked about 114 such pages, and 9 Instagram pages, and we have also done various other types of what do you call interventions now. Now, for the development of an innovative and competitive capital market, we make available new capital market products and services. This will be in tandem with the needs and trends. Example, digital assets. So you would recall that in 2019 we have come out with a prescription order that provides that all digital assets have been prescribed as securities, and many of you know that you can now trade in digital assets through 4 what do you call entities that has been registered by the SC. So I would just like to highlight here that it's important for investors to only what do you call trade on digital assets through platforms that has been registered with the SC. Yeah, there are 4: Luno, Tokenized Synergy, and that's the fourth 4 such entities, and also the areas like equity crowdfunding, PTP platforms, pair change investing, robo advisors, and so on. So we keep in tandem with the development of the market and introduce all these new products. Now, how can SC help potential investors? Yeah, as I mentioned just now, we have established InvestSmart, and this was established in 2014. This is to empower the Malaysian public with the right information, knowledge, and understanding to make informed investment decisions. That with the aim of ultimately building and protecting and sustaining their financial well-being. So, as I mentioned, we view very strongly that investor education is crucial to ensure that the Malaysian public are protected. We have to be one step ahead of the scammers. We have to be one step ahead of the need, and also we have to continuously educate the public to only invest through the right platforms. There are various platforms out there. If I can just take the opportunity to mention here as well, just because an entity or is licensed elsewhere, because we have a lot of entities that may be appropriately licensed elsewhere, but that does not mean they can ply their trades on our shores if they don't have what do you call license or approval by the SC. Yeah. So if someone comes to you and say that, oh, my entity here is been licensed in what do you call Cyprus or Bahamas or whatever, don't worry, we are licensed, whatnot. So, but if they don't have a license from the Malaysian regulator, from the Malaysian Securities Commission, they are not allowed to apply their trades, and SC will take action if you receive information in that respect. For InvestSmart, what we do is that we disseminate our knowledge through various platforms such as printed materials, broadcast channels, digital and social media. We have our social media platforms. Please do visit them, as well as direct engagement such as exhibitions and seminars. Now, in conjunction with Global Money Week, we are also offering to the public free virtual one-on-one free financial planning consultancy under the initiative called FIMM Plan for You. Yeah. This is brought to the Malaysian public in collaboration with the Financial Planning Association of Malaysia, FPAM, and Malaysian Financial Planning Council, MFPC. So please take opportunity to if you're interested for this free virtual financial planning consultancy. And this consultations, you will be having it with licensed financial planners. And these free sessions are available now. It's open until Friday. Yeah? So do check out our InvestSmart social media platforms, our SP, Instagram, TikTok, and Twitter for details on how you can go about registering for this initiative.
That seems
it's called
to be Very,
Yeah,
very
yes.
comprehensive reply, Encik Jawahar Ali.
Yeah.
It seems like you're able to encapsulate everything that SC is doing
Yeah.
in that. But in light of this, right,
Mm.
Miss Winnie Chan from SITRAC itself, because Encik Jawahar did mention something about scams and uh, things like website that is not right, that is being blocked by SC itself. But how would SITRAC what is the role for SITRAC in terms of uh, investment dispute?
So good morning, Faiz. Good morning, fellow participants. So SIDRAC, short for Securities Industry Dispute Resolution Center, is an independent body established by the Securities and approved by the Securities Commission for settlement of dispute between investors and capital market intermediaries. So what we do is that we try to resolve any disputes or complaints between capital market investors and intermediaries such as banks, brokers, fund managers, or fund management companies, private retirement scheme providers, and distributors. So in relation to your question earlier, if there is scams, there's been scams and whatnot. How SIDRAC plays into this is that SIDRAC deals with capital markets complaints and disputes. If it's just a mere scam, like what my Encik Jawahar has said, if it's a banking scam, then it won't fall under SIDRAC purview. It will fall under the purview of the Ombudsman or Ombudsman for Financial Services. So our center is very targeted. We're targeting investors who has invested in capital markets. So we're looking at products such as shares, unit trusts, derivatives, futures. So that's how SIDRAC plays its role. If it's just scams, insurance scams, banking scams, it will fall under Ombudsman. Yeah.
Very, very concise answer. Thank you, Winnie. But for Puan Salawati from FIMM, how would you say your organization is involved in their role in the capital markets, as well as the individual investors and their investing processes?
Thanks so much, Faiz. So essentially, if we were to compare between the SC and SIDRAC, I think FIMM is a bit more underdog to a certain extent. Even though we have been incorporated since 1993, a bit younger than the SC, I would say, because the SC was formed in March, while FIMM was, or rather at that point of time, FMUTM was formed in August 1993. So essentially at that point, we were just an association, for the investment industry. So we make efforts to boost, to boost the growth of the industry at that point. So essentially, if we were to look at in 2011, that's when we were accorded the status of SRO by the SC. So at this point, we are actually reporting to the SC, and our roles are a bit more encompassing to a certain extent because we carry out dual roles as the SRO as well as the industry representative. Mind you, in terms of the scope of our work, is actually confined to the sales and marketing of unit trusts and private retirement schemes. So it's a bit more focused compared to the SC, where the SC will actually looking at the capital market as a whole. So essentially, that's what our roles are. So if you can see from the background of my screen, we actually put in, the kind of roles, specific roles that are undertaken by FIMM as an SRO as well as industry representatives. So I'm just going to go a little bit, in summary in terms of what our roles are as an SRO. So we are the gatekeeper, we are the supervisor, as well as we are the enforcer, because in order for an individual or a company to distribute unit trust funds or private retirement schemes, they have to be registered with us, right? So that's where our gatekeeping role is. So and also, of course, when people are registered with us as an SRO, we need to supervise them, making sure that they follow our codes, they follow our rules, and what more, making sure that they do that, If they don't do it, we enforce. So that means it's actually set some kind of a stance to actually indicate that, you know, you better follow the rules, otherwise, you know, you'll be sanctioned for whatever misconduct that you have committed. So another point that I want to bring up is that we only regulate conducts. So if we are talking about, you know, investor having issues with the investment and lose money, if it is resulted of a misconduct from a consultant, then you can come to us, but we can't compensate you. So the mediation and you know, the compensation that you want to seek for, then you got to go to SIRAC. You know, that's where really is. But as far as we are concerned, we regulate whoever that are registered with us, which is consultant, as well as the company where the consultants are attached to. So essentially that's what our SRO role is. But as an industry representatives, you know, we also conduct training. We collaborate with various parties, SIRAC, SC, to name a few, and other institutions as well, as part of educating the public, as what we are doing now, in terms of what unit trust products are, in terms of capital market products are. So I think we also participated in, you know, the various talks involving scams, because that is also close to our heart. So there are other things that we do, which essentially you can go to our website to understand a little bit more in terms of, you know, the various areas that we look at. Over to you, Faiz.
Thank you very much. But I have a follow-up question. You mentioned the role as an SRO and industry representative, but what are the tools that you use to enunciate these roles of yours towards the public and towards your industry players themselves? What do you do in the form of? Do you have a website? Do you come up with plans? Do you come up with education seminars and whatnot?
Okay, so I because I'm not sure in terms of the demographics of the attendees at this moment of time. I would imagine that given that we have CPD points, so we probably have a mix of consultants as well as the general public, right? So I'm going to I'm going to answer you in those contexts. So if we were to look at consultants, of course, you know, before they can actually come into and start selling unit trusts and private retirement schemes, they must be registered with FIMM. What it entails is they must actually pass an examination. So that's one point. I mean, that's the gatekeeping role that we were talking about earlier on. Then on a yearly basis, they must fulfill some kind of a training requirements. They must fulfill 16 CPD points, we call it, continuing professional development points, without which they have, you know, they will be out from the industry for a while, right? So that is on the consultant perspective. But of course, you know, other than that, we take enforcement actions. If we identify you to have a misconduct, we take enforcement action. And we also, for material misconducts, we also publish that on our website. So that's on the consultant bit, you know. We also, then on the investor side, so I think we have been participating in many conferences. We also have our flagship event, which is FIMM, which is organized on a yearly basis. That is actually open for consultants as well as the public. We have various social medias where we publish educational materials, as well as creating awareness on scams to a certain extent, the rights of the investors, you know, and the expectation that we want from consultants as well. So, you know, there are various means that we have. So we in terms of our website, you can go to www.fimm.com.my. So you need to use the website very, very vigorously, I would say, because if, for example, you're approached by a consultant, you need to identify whether that consultant, in actual fact, is an authorized person to sell unit trust product, right? So that's where you can get all the names. You know, if you know the names, if you know their FIMM number, because every consultant actually being issued a FIMM number, so you can go inside to identify whether this person is still active, or you know, the registration of that person is still valid with FIMM. I hope that answered the question.
That did. Thank you very much. It seems like it is very, as you mentioned, encompassing, meaning that you do take care of your consultants, making sure that the industry is being looked upon in a fair light. So you better, basically, you better take care of yourself before someone takes care of you.
Yeah.
But over to Miss Winnie, I would like to ask, what are the methods that are being used in your industry, especially to resolve the disputes between the capital markets? Oh, Winnie, I believe you are muted.
Yeah, sorry, Mr. Faiz. So CITRAC is an independent and impartial body when it comes to resolution of complaints from the public or from the investors against the intermediaries like banks or fund management companies. So what CITRAC does is that CITRAC goes through the stages of dispute resolution process that we have in place at CITRAC. So when CITRAC receive a complaint from the public against the intermediaries, CITRAC will first inquire whether the complaint has gone to the intermediary in the first place, like the banks or fund management company. So it has to be resolved with the it has to be complaint has to be addressed first at the intermediary level first. If the investor or the complainant is not happy with how the intermediary or the banks, I'm using the bank, but we have a lot of members beside the bank. So if the bank, the investor is not happy with how the bank resolve the complaints, then the complainant will come to CITRAC seeking recourse or redress. So once a complaint is being lodged with CITRAC, it will go through the dispute resolution process where we will have case management, and we will CITRAC case managers who are legally trained, and they have experience in capital market disputes, capital market products. We will assess and we investigate the complaint. Here we will look into the documents that was in the complaint. Maybe it's a complaint about the product that's been bought, like unit trust or shares. Perhaps the complaint, in some cases that we have seen, is complaints against, like what Puan Salawati said. We work together very closely with also FIMM. If it's a complaint for mis-selling for a product that's been bought through the representation or misrepresentation by a unit trust consultant. So that is one of the examples that we, one of the cases that we attend to quite frequently at CITRAC. So once the complaint comes in, case management will kick in, we will investigate, we will assess. And if the CITRAC deems that the complaint has merits, it will move to the next stage of the dispute resolution process, which is mediation. So here we will sit down the CITRAC members or the intermediary together with the complainant or the investor to see how parties can resolve the financial dispute, the complaints that's been brought. If at mediation the dispute can be resolved, fine and well, settlement agreement can be entered between parties. Here, how mediation is to the benefit of both parties, where cordial relationship between the banks or the intermediaries can be maintained with the investor. But if mediation is unsuccessful, the next stage of the dispute resolution process will be adjudication. So here there will be adjudication hearing being set in place, where an independent adjudicator from CITRAC independent panel will be appointed to hear the dispute. So in comparison, what's the difference between the two stages of dispute resolution process? At mediation, parties are still cordial, informal, able to come together to the table to discuss and resolve it. But at adjudication, no, parties are coming with evidence to see, and then there will be an adjudicator deciding based on the facts and evidence presented. So these are the tools that the investor has at CITRAC when they have a financial complaint, financial dispute against the capital market intermediaries. And how CITRAC plays a role is that we want to be a one-stop impartial avenue for resolution of dispute considering monetary claims in the capital market products and services. And we do work very closely with with the SC through our awareness program, InvestSmart, to ensure that the public is aware that have this, that all is not at end when they have this financial problem or financial dispute against the banks, against the capital market intermediaries. So they can come to us with their complaints, and we aim to resolve it.
Thank you, Winnie. Earlier, Puan Salawati mentioned that FIMM does not involve themselves with compensation. But is that true for SITREC, or is the part of the process of this remediation and education is to achieve a compensation by at least by one of the party?
So the aim for SITREC is actually to resolve a complaint, to resolve a dispute between parties. If parties at mediation are able to come together to resolve it, not necessarily a monetary compensation, but a solution to their dispute, then we believe that the aim of mediation has been achieved. Mediation is successful. But again, we don't term it compensation. It can be looked as a compensation, but it's not. It's actually a resolution to the dispute. If it's in terms of monetary compensation, then fine and well. That is how when I said that a settlement agreement will be entered between parties to resolve in terms and conditions to resolve the dispute. So if it's not resolved during mediation, it will go to adjudication here, and adjudication will issue an award. Again, depending on the decision, the investor or the complainant or the claimant will either get a full award, which is the decision is for him, or no award at all. This case is dismissed against him, and or there's a partial award. Decision for divided between the member and the claimant.
May I know, for the benefit of the audience as well, is the recommendation or the decision made by the education binding, or are they able to appeal it all the way to the courts?
Yeah. So we have two schemes. So the decision that is in the mandatory scheme is binding on the member. The claimant has the right to either reject or not accept the decision. But in the mandatory scheme, because SITREC has the two different schemes for the amount of claim that's been put for a resolution. If it's below 250,000, so it falls under SITREC mandatory scheme. If it's above 250,000, then it goes under SITREC voluntary scheme. So if it's a claim that's below 250,000, both member and claimant has to submit to SITREC's jurisdiction. But if it's above 250,000, the agreement of both parties has to be obtained for them to submit to SITREC's jurisdiction. Yeah.
Understood. Going back to Encik Jawahar, you mentioned a lot of roles that IC has been taken, but in terms of blocking the websites and blocking the Facebook, how would you say you go about it? Because there's so many websites out there, and in Malay they would say cendawan tumbuh selepas hujan. You mentioned a few hundreds, but websites such as scam websites are plenty. So are the actions taken by SC a bit more after the fact, or is there any proactive actions that are being taken by the SC, and how would SC do it?
Yeah, all right. We do this via two. One is what we call proactive. The other one is what we call reactive. Now, when I mean reactive, it means that we act upon information that we receive from the public, which through our complaints channel. Yeah? So we have a dedicated complaints channel. We have a hotline. We have a dedicated email where members of the public can send us their complaint or inquiry. And based on that, we will assess. And if we come across a website that we view that it is breaching our laws, we will make an application to the MCMC to block the said website. Now, the other approach that we call is through proactive. That means that we have a team, a dedicated team that proactively trawls the net, looking for if there are any of these such entities that are carrying out this unlicensed activity, that there are currently a lot of these things are being done manually, but we are looking into acquiring a system and doing it a bit more in a structural manner. But to answer your question, we do it through two approach. One is proactive, the other one is reactive. So we hope, with this we will be able to capture many more of such what do you call unlicensed and scam websites.
Jawahar, I'm pretty sure that your website gets a lot of complaints. As in, a lot of people file complaints against this and that. How would you choose which one to address first? Is it based on the amount that is being scammed, or is it based on the number of complaints?
Well, we would. There's no really that's not really a criteria. So what we normally do is that if we were to receive information, even though it's only one complaint or even one inquiry, and if we view that particular website is carrying out an unlicensed activity or scam, we would act upon it, immediately. You see, but of course, if there are many complaints received against a particular entity, then it would give rise, it would give what do you call we would consider options towards initiating an enforcement action or some other initiatives. You see, but what we will do is that when we receive an information, immediately we will want to protect the investors. That's where we will put them on our investor alert list and block the websites and geo-block the social media pages of the offenders and whatnot.
All right. How often is the block list being updated? Is it daily or is it weekly?
Almost daily. Almost daily. So what we do here is that once we receive the information, we will review it on a daily basis. All the information that we receive to our Adwan channel and the information that has been picked up by our surveillance team. We will go through them and we will act upon it almost on a daily basis. Of course, there may be days that we didn't find any, or we didn't receive anything. But apart from that, we do it on a daily basis. And suffice to say that we do receive it on a daily basis. There are new cases that we receive almost on a daily basis. So we act upon it as and when it comes to us.
Right. Thank you, Encik Jawahar. I would like to remind that to the audience that there is a quiz at the end of the session. So stay tuned, yeah. Okay. So now I would also like to highlight that the theme for the Global Money Week for 2023 relates to sustainable investing. So since sustainable investing is becoming more prominent and that there is a greater demand for sustainable investment products, there are also instances of greenwashing, meaning they market themselves as ESG compliant, for example, but perhaps they're not compliant. I would like to forward this question to Puan Salawati from FIMM. How does your organization protect the investors from any of these misrepresentations?
Right. I think any form of misrepresentation is not right. Yeah. So I think as far as SRI is concerned, at this moment of time, we have yet to see a case involving SRI. What we are, as I said, in terms of our roles, we are focusing on, sales and marketing for unit trust and private retirement schemes. Any misrepresentation in respect of that unit trust, private retirement schemes will then actually come to us to a certain extent for us to look at whether there's really a misrepresentation, particularly in terms of the nature of the products. So as SRI being the nature of the product is also one aspect that we probably are looking at, and also whether there's a acceptance of cash, unauthorized marketing of products. You're not registered. Products which are not registered, product that's not approved by the SCs or the relevant regulators. So those are the areas that we look at, and also for people, consultants probably accepting cash, which is a prohibited act under our laws. So those are the areas that we look at. So essentially what we look at is not solely on SRI, But if there's some misrepresentation in respect of a fund where, it's not a SRI fund, as you know, the SC actually publish on their website on the funds that are designated as SRI. So if that happens, then it's something that we can also look at. I think in terms of other roles that we undertake, of course, the ongoing education, we're talking about, being part, we make a collaborative efforts with the SC and Vietnam. We are also part of the joint committee under JC3 on climate change. So these are some of the initiatives, not so much of taking action, but rather our contribution on the SRI front.
Thank you, Salawati. But going back to Winnie, do you expect, I mean, I understand that SITRAC, maybe the, correct me if I'm wrong, maybe the dispute that are being filed is against monetary considerations. But going forward, do you expect there to be disputes being claimed against funds that are not, in this case, whitewashing or greenwashing, funds that are being claimed to be green, but in fact it's not? Would that be under your purview? And if it is, how do you see it being handled by SITRAC?
Okay, thank you, Jeff Faiz. That's a very good question. So, so SITRAC handles complaints or disputes that is been lodged or against the SITRAC members. So, if it's a complaint that's against SITRAC member, it will come under SITRAC's purview. And in respect of the products that's been sold by, as long as it's been sold by SITRAC member, SITRAC will be able to tag in those cases. So yeah, we do receive complaints for products that is allegedly under ESG or supposedly legitimate. But if it is not under SITRAC's member, if it's not against SITRAC member, so SITRAC won't be able to take in those claims.
Understood. Over to you, Encik Jawahar. So, as we know, the SC does publish a list of counters that are ESG compliant. But that means the whole ESG itself is the purview of determining if it is ESG compliant or not is under you. But how do you tackle companies representing themselves as ESG compliant, but not, in this case, greenwashing themselves, their own funds or counters?
Yeah. Well, SC, with respect to, SRI, we do it through a facilitative SRI ecosystem, so that the whole market can grow in an orderly manner. And just to give you a bit of a background, in 2019, we introduced an SRI roadmap, which made various recommendations and also strategies with respect to how the SRI market will grow. Now, we have along the over the years introduced various guidelines and frameworks to encourage the introduction of the SRI instruments in Malaysia, and we've also introduced an SRI Sukuk framework way back in 2014 to facilitate the financing of sustainable and responsible investment initiative. Now, to this, almost 19 billion has been raised cumulatively under the SRI Sukuk framework. Now, talking about specifically on greenwashing and whatnot, how do we do is that, to encourage greater growth, we issue, as I mentioned just now, various guidelines and framework, the guidelines which this enables funds to be designated as SRI funds. We have in our website funds that has been approved as SRI funds. So if if members of the public will want to be guided, they can be guided with the list, and recently, as recent as February 2023, we revised the guidelines on SRI framework. This revision further enhances the disclosure and reporting requirements of the guidelines on SRI funds. Now, this would have the objective of further protecting against greenwashing. Now, what these guidelines provides is that, among others, includes a minimum asset allocation threshold for a SRI fund. As at December 2022, there are 58 qualified SRI funds with a total NAV value of 7 billion, slightly more than 7 billion, and 34 of these funds are Sharia compliant. Yeah, so again, to answer the question succinctly, this is done through the framework that we have, guidelines, and also to constantly evolve to enhance the current framework that we have. Specifically, we have introduced new measures as early as what do you call February 2023.
Thank you, Encik Jawahar. So right now we're going to start answering some questions from the audience. Looking at this question, I would like to point this to Winnie from SIDRAC. Are the services from SIDRAC free, or do the complainants have to pay for them? Oh, Winnie, you muted again.
Thank you, Faiz, for the question. So a very common question like what you have just posed, do investors or do complainant has to pay for SIDRAC services? So for SIDRAC services is free for disputes involving claim not exceeding 250,000. So this will fall under SIDRAC's mandatory scheme. But if the claim is above 250,000, so there is a prescribed fee under our SIDRAC's terms of reference that the complainant and the member has to pay. But it's free of charge for claims under 250,000.
Right. A follow-up question for Winnie. As you mentioned, that above 250,000 case size, if I can put it that way, is voluntary basis. Does that mean the SIDRAC members themselves has the ability not to volunteer or not to go through the process?
Yes, that is correct. Your understanding is right. Again, both the agreement from both the complainant and the member has to be obtained before they can submit to SIDRAC's process for voluntary scheme.
Right. So what would be the complainant's steps that they can take if the SIDRAC member does not want to proceed with the resolution or the, as you mentioned, remediation?
So if the claim amount is high, above 250,000,
right,
and the member chose not to go through the process, so the claimant has other recourse besides SIDRAC, perhaps to take the matter to court or other avenues for recourse. Because the agreement to submit to SIDRAC's purview for this 250,000 and above claim amount has to be there.
Right,
That's why
right.
it's the
Understood. Thank you very much. Over to Encik Jawahar. What would be the consequences if investors invest in companies that are listed under SC's Investor Alert List, including for those companies that have registered or recognized by other countries' regulators?
Yeah, of course. I think the most glaring consequence would be that any one who invests in entities that are on our investor alert list, they would not be provided the necessary protection. Yeah, that would be accorded if they were to invest in an entity that is regulated or properly licensed by the SC. Now, that is the reason why we license an entity, in order for a CMSL or even the CMSRLs to get a license, they have to go through various vigorous requirements. Yeah, and all of these requirements are designed with the main purpose of investor protection. You see, so if one were to invest in a company that is offshore companies here, for example, they claim, oh, we are licensed by Bahamas, and you transfer your money to offshore or whatever. In the event of a dispute, you will not have a recourse. So here you can go to SIDRAC. Assuming if you have a dispute, you can go to SIDRAC, or there are various other recourses that you can seek, legal recourses that you can seek. But if you were to invest through an unlicensed entity, you will not have this recourse. So that is very, very important for one to remember.
Understood. Now, for this question, I'm going to ask all of you, but I'm going to start with Salawati. If a client, investor has issues with his or her investments, uh, being a retail investor, should they go through FIMM first and then go to CREC and SC, or would you say the order is different?
I think it depends on the product that they want to invest in, right? So I think the first port of call would have been to deal with the provider of that product, right? So that will be the first port of call. Only when you can't come to an amicable resolution. If it's talking about unit trust product and private retirement scheme, certainly you can come to us. It's not in the order of priority. You can also go to the SC, FIMM concurrently. Then the two of us, the two organizations will typically collaborate, looking at the complaint, sharing information of what's available. So that avenue is actually quite open. So as I said, if it's talking about other capital market product, right? We're talking about equities and all that, but of course, it's under within the SC and Bursa's purview, then probably, those are the place that would probably best fit to lodge the complaint.
Right. Winnie, do you agree with that assessment?
Yeah, I do agree with Puan Salawati. One of our processes before even a complaint can be lodged with CIDRAC is that the investor must lodge the complaint with the CIDRAC member or the capital market intermediary. And then from there, they will take, and from there, if there is no resolution or the investor is not happy with the answer given by the intermediary, and then they will come and lodge it with us. But it's a very important requirement that a complaint has been lodged with the CIDRAC member or capital market intermediary, and it cannot be resolved at that stage. Only then it comes to CIDRAC. But at the same time, if the investor chooses to lodge complaint with, for example, with FIMM, with SC, they are free to do so.
Understood. And Encik Jawahar, so let's say if an investor has already lodged complaints with the institution itself, the market representative, and then with FIMM, and then with the CIDRAC, where does SC come in?
Well, we will look into whether any of those breaches or potential breaches or the facts of the case gives rise to any potential breach, and if it does breach any of the possible breaches under the CMSA, Capital Market and Services Act, the act that we govern, we would be accordingly taking enforcement action if it meets those criteria. You see. And yeah, we will be looking into the conduct of the intermediaries as well as the conduct of the CMSRL or registered persons in this case. Like we're talking about FIMM, all those registered person, and if there gives rise to a breach. An example of a breach that I would like to highlight is, what we call securities fraud. You see, whereby if we determine that the facts gives rise to a fraud that may have been committed by CMSL or even anyone for that matter, we would take action. Here, I would like to just I give this advice at every opportunity that I get. Because one of the reasons that we see a lot of these frauds happen is because when the investors, they transfer their monies into individual bank accounts. Yeah, we note that, say, for example, they say, oh, for the purposes of investment, please transfer the money to account of Ahmad bin Abu. So here, I would like to advise that in no circumstances that you should transfer money for investment into any individual's bank account, even if that particular person is a licensed or a registered person. If he says, oh, I'm actually a registered unit trust consultant, so can you please transfer your money into my account? So do not do that. Your money must only be transferred to the formal account of the entity that is licensed by the SC.
Thank you, Encik Jawahar. That marks the end of the session, including the question and answer session. So I would like to thank all the panelists, Encik Jawahar Ali, Ms. Winnie Chan, and Puan Salawati, for attending the session, as well as all the audiences for staying until the end.